Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. Before we call the first case, I want to take just a few moments and talk about our procedure. Then I'll introduce the panel and we can begin. First of all, I know we have experienced practitioners here, but just to be sure, I wanted to run over the ground rules. Each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time. Proper process to use to do so, though, is after you've come to the podium and introduced yourself, you can request that from the court. Obviously, the appellee gets no rebuttal time. If there is more than one party to a side, we expect you to tell us when you come to the podium to begin your argument how you're going to share time, if in fact you're going to share time. Also, we have a lighting mechanism on the podium. Once you begin your argument, a green light will come on. As long as that light's green, you got plenty of time. Once the light turns yellow, it means you're running out of time, and once the light turns red, you're out of time, and we ask that you please respect those time constraints. One of the most important things that I think you need to be aware of is that all these arguments are being live streamed. That sounds very generic and very vanilla, but it is very important to you all as well as to us, because whatever you say, it's out there for everybody to hear. So think carefully about what you say before you do say it, because we've had some embarrassing situations arise in the past. Your panel this morning will consist of Judge Karma McGee from Savannah, Judge Christy Davis, who was so excited that she drove all the way down here from Knoxville just to be with us. So we're thrilled to have her here. This is her maiden voyage in Jackson, I believe. So welcome. And I'm Steve Stafford from Dyersburg. Ms. Angie, anything we need to take up before we call the first case?
No, Your Honor.
You may call the first case, please.
Betty Malia Bryant versus Shelby County Government et al.
And we will hear from the appellant.
Good morning.
Good morning.
May it please the court, my name is Yvette Kirk, and today I'm appearing along with Maureen Holland on behalf of the appellant Betty Malia Bryant, who is also in the courtroom today, but I'll be the one speaking.
All right.
And I'd also like to reserve 3 minutes for rebuttal.
3 minutes.
All right. This appeal arises from Ms. Bryant's termination in March 2020, just before COVID, after more than a decade of service as lead cashier at the Shelby County Trustee's Office. The county terminated Ms. Bryant based on vague allegations without following its own disciplinary policy and in contradiction to her recent positive performance reviews. The Civil Service Merit Board then affirmed that termination, and the Chancery Court upheld it. Both rulings were in error, and we respectfully ask this court to reverse on 3 grounds pursuant to Tennessee's Uniform Administrative Procedures Act. First, the county failed to provide adequate notice or a meaningful opportunity to respond in violation of due process under Loudermill. Ms. Bryant was not told what specific conduct justified her termination or was given the chance to meaningfully respond to it. Second, the county disregarded its own progressive discipline policy, Policy 703, which mandates that discipline typically proceeds in escalating steps, from warnings to suspension before termination is considered. And finally, that the termination was arbitrary and capricious and unsupported by substantial and material evidence. I'll begin with the due process argument and then turn to the policy failures and evidentiary issues, which follows the chronology of our brief. So let's begin with the March 2nd, 2020 Loudermill notice. That notice was supposed to alert Ms. Bryant to the specific charges that could justify the major discipline against her, up to and including termination. But in Ms. Bryant's case, it did not. In this notice, it only listed vague terms like numerous errors, dishonesty in transaction activity, and insubordination, but gave no dates, no explanation of the conduct, and no documentation to support this. It didn't mention the February 24th, 2020 event that the county later said was the basis for her receiving this notice and later dismissal. And in the notice itself, it said that suspension with pay was the likely discipline being considered. She was never told, you're being considered for termination because of what happened on February 24th. Instead, she received a generic letter and only later learned during the hearing process that this minor drawer issue on February 24th was allegedly the basis for the notice.
What's the effect of the hearing procedure, though, actually having a hearing itself when all this information is disclosed?
Well, yes. While the hearing itself can showcase some events, Ms. Bryant, we say that Ms. Bryant wasn't told what the conduct was actually under scrutiny.
We say, but what does the law say about a full hearing being provided?
It says that yes, in Moss versus Shelby County, obviously the totality of the record is taken into account. But we allege that even at the end, when she was provided her termination notice, it didn't specify each individual event that led to her termination.
Does it have to?
Well, here, I think that the lack of clarity is the biggest reason here, is because Ms. Bryant went into her...
Let's go back to my question. Does the order have to specify each event?
The notice itself, under the law, does not necessarily...
No, not the notice, the order for after the hearing. I assume that's what you're talking about.
No, I don't. There was no order after the hearing. There was just a letter notifying her of her termination.
Okay. But you did have a hearing, correct?
She did have a hearing, yes, sir.
And at the hearing, were all these matters that the county now relies upon discussed and brought out?
It's my understanding that they did question her about different events, yes. And then I will go into what those events amounted to and whether or not that termination was the right recommendation based on what was discussed.
So there's no question that she was aware, at least at the hearing stage, about what events were relied upon by the county to terminate.
Sure. Well,
is that accurate?
I think our argument focuses on whether...
No. Let's talk about the record. Is that accurate?
Can you repeat your question?
The events that the county relied upon to terminate your client, were they discussed at the hearing?
Well, I think that the vagueness is part of the question, because while during the hearing...
Go back. This is a yes or no answer.
Well,
were the events that the county relied upon to terminate your client, were they discussed at the hearing in which your client participated?
Well, Your Honor, I think that the issue here is that even if events were discussed during the hearing
Can I
itself,
get a yes or no before you explain your position?
Okay, well, while yes, specific events were discussed
Now you can
hearing.
Okay, now you can
yes,
explain.
Following that discussion, she received notice of why she was being terminated, and specific events were not listed as the reasons for their basis of termination.
In the order itself?
In the order itself, following the hearing, yes, sir.
Okay,
yes,
okay, so it's not a question of she didn't know what they were relying on. Is that accurate?
Well, I think the answer is that on her way to the hearing, she was not made aware, and able to prepare to respond to specific events that they were going to question. Now, did they ask her specific questions at the hearing about events? Yes, they did. Were there a few items in her disciplinary record? Yes, there were, but even in their termination notice, it did not list that they were relying on these specific events that were the basis of her termination. It was more broad, vague language. All right, but I will move on to our next argument, and that is that setting aside due process, we argue that the county also failed to follow its own internal standards because Shelby County Employee Policy 703, which governs discipline for civil service employees like Ms. Bryant, requires that disciplinary action be of an increasingly progressive nature. And that means the county was expected to impose lesser forms of discipline first.
And what language can you point to in Rule 703 or policy number 703 that specifically requires what you're alleging? What mandatory language? Because from my recollection, Rule 703 uses the terminology typically proceeds, not anything else. So what language are you relying on specifically to support your argument coming from 703?
So while, yes, Policy 703 allows discretion, it still requires a rational basis, and usually there's documentation or an articulable reason why termination was justified. And in terms of the discretion, we're not arguing that there is no discretion under 703, but under 703, if I can, I'm sure it's, I know it's listed here in the brief on pages 21 and 22, it lists the employees may be, employees in the classified service may be removed, demoted, reduced in pay, or suspended without pay, or placed on probation for just cause. And then the language of the Uniform Administrative Procedures Act articulates that that must be based in a rational basis, based on the fact that the court can reverse, if the decision was found to be arbitrary or capricious or not based in substantial material evidence.
So in essence, you're not saying they can't terminate her. You're saying they didn't provide a sufficient reason?
Well, it says that Policy 703 allows for discretion, but not arbitrary discretion, and there must be a reason to skip steps.
So is that accurate? They didn't provide a sufficient reason for termination or skipping to the termination?
Yes, sir. Yes, sir. Because in this case, the totality of the disciplinary is 2 cash shortages from early 2019 that caused a probationary period. Then she receives a very positive performance review in 2019 that says she's an asset to the department, that she works great alone, she works great under pressure, she's very knowledgeable. And then in early 2020, there was an insubordination write-up that was very specific and related to an issue where Ms. Bryant requested, and the county had agreed to provide her escorts when she's taking large sums of money to the bank. We're talking $40,000 or so to the bank. And on that day in question, Ms. Bryant was told she would not have an escort. And Ms. Bryant had been personally mugged in the past. And so the county had agreed to provide her this escort, and they had also agreed to provide other people this escort. And so, understandably so, Ms. Bryant became very distressed and, raised her voice, and they may have had a discussion and resulted in a write-up that was, a handling of the discipline in an appropriate way at the time. Following that event, Ms. Bryant the county provided Ms. Bryant with the escort. And everything was handled internally, and no other insubordination or incidents related to this very specific mugging concern happened. And
Excuse me just a minute, wasn't there also a shortage around that same time that may or may not have been partially due to a computer error, but there was a shortage around that time as well?
Yes, ma'am, yes. So that is the only other incident that occurs in her entire disciplinary record, is that there was an issue on February 24th where it showed that there may have been a shortage of almost $70. However, once Ms. Manis, the supervisor, went in, she realized that it was actually a glitch and that the shortage was only about $9.68. And Ms. Manis testified during the Merit Service Protection Board hearing that only when there's a shortage of about $20 or more does she even get involved. So they view shortages of less than $20 as not even necessary for supervisory
But didn't she
involvement.
try and force balance it or something, and that was not an acceptable way to handle that?
Yes, I think they did not like the technique that Ms. Bryant was utilizing. Now, of course, we're talking about a 10-year employee who was trying to handle the situation and how she knew, and obviously Ms. Manis had some different policy ideas about how to handle the situation, but what we're talking about is a shortage of less than $10, and had Ms. Bryant been made aware that it was actually a glitch, she likely would have handled it very differently. Of course, that's speculation, we don't know.
Cumulatively, what you're looking at, though, is over the course of 1 to 2 years, you've got basically 4 instances of potential performance issues. Would you agree with that?
While you can look at it from that perspective, the 2 incidents in early 2019 were followed by a very positive performance review, which specifically says and addresses the 2 issues from earlier that year, and said that we are that show that Ms. Bryant had made positive steps in improvement on those 2 types of issues that took into place Ms. Manis's direction on how to handle cash shortages. So what we're actually looking at is one very specific insubordination issue that was related to a personal, mugging situation, and distress from that, understandably so, which the county provided the requested escort that she was looking for. So that's a very singular event. And then the next event is a cash shortage that turned out to be less than $10 that typically would not have even risen to the level of supervisory involvement. And not only that, but going back to the...
You've used your time.
Oh, all right, okay, all right. Thank you very much.
Thank you.
Good morning.
Good morning.
Catherine Frazier for Shelby County. I think that the due process argument, I would like to address that first. I believe that Laddermill actually supports your review of the post-termination procedures. In Laddermill, and I didn't emphasize this in my brief, but starting at page 546 through 547, the court says our holding rests in part on the provisions in Ohio law for a full post-termination hearing. And the court goes on to address whether or not, drops a footnote, and the part of that says, finally, the existence of post-termination procedures is relevant to the necessary scope of pre-termination procedures. Likewise, in the Moss case, this would be one that's obviously very familiar to my office, since we had a series of those cases. This is from the 2020 Supreme Court opinion. The court looks at the pre-termination letter, the post-termination letter, and then it notes, in addition, the actions of Mr. Moss and his counsel at the hearing before the board conflict with the claim that Mr. Moss did not know about the allegations against him. And I hope that you all will agree with me, Ms. Bryant was represented by very competent, capable counsel at her Civil Service Merit Board hearing. Counsel made objections, counsel cross-examined the county's witnesses, counsel presented Ms. Bryant's case in the best possible way to the board, and presented exhibits to the board that supported Ms. Bryant's position in the case. So I think when you look at the due process issue, like Ms. Kirk indicated, the totality of the circumstances are taken into account, including the appearance before the Civil Service Merit Board. Now, in this case, there were numerous cash outages. Ms. Maness, who was Ms. Bryant's direct supervisor, testified that she began coaching Ms. Bryant in 2018 regarding the cash outages and implementing procedures to address those concerns. Ms. Maness did not want to discipline Ms. Bryant, and frankly, the discipline policy itself says that supervisors should speak with the employee and try to correct action before ever getting to issuing discipline. That's exactly what Ms. Maness did. And when we got to 2019, she started issuing discipline, and she noted in her 2019 performance review that a cash transaction method that was being put into place was not being used by Ms. Bryant, leaving a lack of cash audit trail. And she put in there, Malia has been counseled and corrective action taken, which has placed Malia on a 12-month probation. So Ms. Bryant, Malia is Ms. Bryant's middle name. Ms. Bryant was on notice starting in February of 2019. There's a problem. They noted that problem in her performance evaluation in the summer, and Mr. Harris, who is the HR manager, testified that he put Ms. Bryant on final warning in the summer of 2019. So Ms. Bryant was made aware that there were problems. Regarding the insubordination, Ms. Maness and Ms. Bryant testified that they had conversations about her insubordination starting in 2018. So none of this was a complete surprise to Ms. Bryant when the Loudermill notice was issued to her, and that Loudermill notice clearly said that termination was being considered, and Ms. Bryant knew this because the letter about the insubordination incident with the trustee also said if anything else occurs, termination may be considered. So it's our position that Ms. Bryant was afforded complete due process throughout the entire procedure, including being represented by competent counsel at her Civil Service Merit Board hearing. Regarding the discipline, the testimony, or the procedure, the actual policy says, you said typically, it says usually progressive steps in discipline, but not always. There's no requirement that we follow each step. And Mr. Harris made it clear that steps can be taken or steps can be skipped, and that he felt in this particular case that was warranted. Ms. Maness also testified about that because the board asked her, why didn't you consider suspension? And she said after having multiple conversations over and over, we got to the point where we just concluded that Ms. Bryant could not do the job. And that is unfortunate, but that's what the events revealed. Now, with respect to the arbitrary and capricious, the board found that there was sufficient evidence to terminate. They also found that the trustee's office did not really have an alternate choice because everything that they had done to try to course correct Ms. Bryant wasn't working. The chancellor also found that the board's findings and rulings should be upheld, applying the same standard that you all have to apply. And so it is our position that the record is filled with evidence regarding Ms. Bryant's inability to perform this job. Now, I will say, I did mention this in my brief, at some point, the trustee's office, before Ms. Maness and Mr. Harris worked there, used to require cashiers to put their own money in to make up the difference if there was a shortage. And I am glad they stopped that, because that sounds like a bad policy to me. Ms. Maness and Mr. Harris took that policy away. They said, we're not going to do it that way anymore. We're going to have an accurate count of every single dollar that the trustee is collecting. That is important because it's all taxpayer money This isn't some private bank that might have had somebody messing up. This is a county who is collecting tax money and is obligated to be able to show the citizens every dollar that comes in and where every dollar goes out. So I do think that because the accounting aspect of the job got more technical and more specific, that may have also impacted Ms. Bryant's ability to do the job. But the bottom line is the trustee has to account accurately for information or tax dollars that are collected. The last thing I wanted to address, and I think you brought this up, the last cash shortage in February, there was not a glitch in the system. Ms. Manus testified that the way their computer program was set up, there was a button that they were never supposed to press. And so Ms. Bryant figured that out, and I think Ms. Manus called it a workaround. She figured out how to make the machine print a receipt for money, but it wasn't actually capturing the money in the computer system. And that's why there was a difference in the shortage. But it was Ms. Bryant who used the machine improperly to create the situation. It's not a glitch in the trustee's computer program. And so in terms of her performance, they tried for 2 years to help Ms. Bryant. They did everything they could to avoid disciplining her. But in the end, with the cash shortages, the insubordination, going on, they felt that termination was the only realistic outcome here. Unless you all have questions.
As far as there's been an illusion, perhaps not an illusion, but a statement made that she couldn't do the job, and that's essentially part of the termination. Would that be accurate?
Yes, yes.
Is there any obligation on the part of the employer to look for other positions?
I believe that Mr. Harris testified at the hearing, and I may not have cited it in my brief, that he did not think there was anywhere else he could put her. He would have been the decision maker about that. I don't know that there's an obligation on the county to do that, but that is certainly, steps are taken when we have that kind of situation,
So
if it's
that
possible.
was a consideration, and
Yeah, I mean,
that's part of the proof. That's part of the proof.
Yes.
Either at the, I assume,
The Civil Service
there was
Merit
no new
Board.
evidence introduced in the Chancery Court, was it?
Yes, it would have been in the Civil Service Merit Board transcript.
Okay.
So, anything else?
Thank you.
Thank you.
As you just heard from appellee counsel, they're making a lot about Ms. Bryant's alleged inability to perform her position. However, beyond the events that we've described, there's no documentation of a decline. Ms. Bryant was serving as lead cashier, which meant that she was going around to individual locations around the city, Bartlett, Germantown, where she was the only person interacting with between 150 to 200 people taking their taxpayer dollars, and usually what she had was a printer and a calculator. They used to employ kiosks, which would take the money and help interacting. And in this situation, Ms. Bryant was solo most of the time trying to perform this huge job. So while they're claiming that she somehow was unable to do it, and especially after they tried to help her so many times, however, Ms. Bryant was never placed on a performance improvement plan. She was never given additional training. She was never suspended or demoted. And she was again told to continue to keep going out in the field and performing this position, which is a indication more of confidence in her ability to perform rather than a lack of confidence. And additionally,
You say there was never a remedial plan. Opposing counsel says that there were lots of discussions about trying to help her.
yes. So what opposing
Is there a
counsel?
distinction there?
What opposing counsel is referring to is that in her MSPB testimony, Ms. Manis testified that she'd have a lot of conversations with Ms. Bryant because Ms. Manis, who was more new and had different policy ideas and was implementing new policies, would talk to or counsel with Ms. Bryant about implementing those in these high-pressure situations. But it was never discussions about, which is what the progressive disciplinary 703 contemplates, that you do want to go through earlier stages to see if you can help the employee to perform, especially if they're a well-performing employee with positive evaluations, which is what we have here. And additionally, even as opposing counsel is talking about Ms. Bryant's, they're doing everything they can to help her, but there's no documentation beyond just informal counseling that there was some sort of deteriorating performance.
Is there not some type of a new procedure or something that, I believe the briefs referred to this, and of course I haven't looked at the record, but I've read the briefs, and if I recall correctly, there was a new procedure that Ms. Manis had or something that she had put in place, a certain procedure that was supposed to correct some of the recurring issues that they were having, but was there not some testimony as to that effect, and that Ms. Bryant did not follow that procedure?
That is different from it's my understanding that is different from the February 24th situation where she's, opposing counsel testified that there was a button issue, but that situation was addressed during the 2019 evaluation where it was described that by Ms. Manis that she had been working with Ms. Bryant to implement that new process, and that Ms. Bryant had been making improvement on implementing that process that you're describing. And I just want to briefly mention that when we're talking about Mr. Harris and some sort of steps that he took to look for alternative positions for Ms. Bryant, Mr. Harris's testimony during the MSPB hearing was that he's allowed to skip steps in extreme circumstances, and the extreme circumstance that he gave was in the case of an employee showing up to work and shooting coworkers, and in that case you can skip progressive steps and just go straight to termination. And obviously that is way overstating the situation that we have here, which underscores the lack of substantial material evidence that bases their termination decision. Thank you.
Thank you. Thank you, counsel. We will review the record, take this matter under advisement, and attempt to get you an opinion at the earliest possible time. Thank you. You may be excused.